Hi, is everyone available? Hi, Mr. Ahmed. Hello.
Yes, good morning.
Yeah, good morning. Hi, Mr. Chima. I will
Yes,
ask my colleague to just confirm with me, Mr. Ahmed. Mr. Ahmed, can you hear us?
Okay, I can hear you better now. Please, I did not hear what you said earlier.
I will request a confirmation from Mr. Ahmed. Mr. Ahmed Juma, are you with us? Mr. Ahmed.
Can you hear me?
Hi, yes, Mr. Chima, I can hear you.
Yeah. Okay, thank you. I thought you
Yeah,
were
I just
referring to me.
sure. I just request a confirmation from Mr. Ahmed Jumal Rais. Uh,
Okay, that's fine.
Judge. Yes. Mr. Ahmed. Okay, we'll just wait for a minute, then we'll proceed. Can I request a confirmation from senior counsel from appellant and senior counsel from defendant side?
Yes. Yes, I'm the senior counsel for the appellant and I am present.
The senior counsel for the respondent will join shortly.
Okay.
Okay. So meanwhile, I will request a confirmation with the names of the senior counsel, junior counsel, appellant, senior counsel, defendant, junior counsel, defendant with the names.
Okay. How do you want the name sent? Should we send it on the chat or I should state it?
Okay, you can send it through chat as well. And what you can
Okay.
do, either you can pronounce or tell me your name in an order so I can write it down. It is
Okay.
better you
Senior
it is better you do it in the chat. It would be better.
Okay, let me do that now.
Yeah.
Yeah, Mr. Chima, can you also request your team to join in?
You said?
And likewise with Ms. Shakira, can you request your team to join in quickly?
Yeah, she has some audio issues right now.
Okay, okay.
Can I request Rover Sana to confirm the availability of Mr. Ahmed Juma Al Raisi,
P Ibinovia Abi.
Judge?
Yeah, I'm just checking. Just give me a
Um,
minute.
Excuse me.
Yes.
Can the senior appellant use the same device as mine, like in terms of like talking?
Yeah, it's fine.
I think
It's
that should be
fine.
fine.
Okay.
Recorded.
It's okay, it's okay. Good morning.
Mr. Ahmed, good morning.
Can you hear me? Can you hear me?
Yeah, loud and clear.
Okay, I'm sorry, I just was trying to be in, but it was some, I think, technical issue. However, I can see all of you and I can hear all of you. So this is a technical for the first day. Vishal, I'm happy to be with you today. And I think you have started something regarding calling the students and to just check all the attendees are available.
I'll request the attendees to turn on their camera if possible.
No, I mean now we have not all of them, but I can see some of them are there, right? Vishal,
Is the
can you
senior
hear?
is the senior counsel from the appellant side present?
Okay, Vishal, let me handle this a little bit, please. Just give me the chance. Now, who is representing University of Benin? The appellant.
Yes, Your Excellency. Good morning. My name is
Good morning.
My name is B.C. Chima. I am the senior appellant counsel representing University of Benin.
Okay, so I can see your team and all of your team are attending this session, right?
No, my team member is right here with me, is present. Being that the proceeding is firstly between the senior appellant counsel and the senior respondent counsel, then before we go to the junior appellant counsel. But my co-counsel is presently here.
Okay, so now
Thank you.
for the Middlesex University, the senior respondent.
Yes, I'm present here.
Okay, so Mr. Fisher, I think now we have the team with us. So shall we start the session?
Surely.
Okay, just let me give introduction. As all of you are aware that this session will be last for 90 minutes. Each team will be granted 45 minutes to present their oral submission and discussion. And then we will have 15 minutes for the questions and feedback as being listed. However, the session can be ended earlier if all that if both teams delivered all what they have, what they have to submit. So as we are aware now, this is a DEC, Digital Economy Court, and we are now having University of Benin as an appellant and Middlesex University as a respondent. And now, Mr. Vishal, it's the time for you now to just start this one.
Yeah. Thank you, Mr. Ahmed. I'll request the senior counsel from the appellant side to present their facts and proceedings.
Thank you, Your Excellency. May it please the court, Your Excellencies. The senior appellant counsel, on behalf of the appellant, filed the appellant bundle dated the 4th. It's dated and filed the 4th of November 2022, and in it we've raised two grounds upon which we are going to make argument before this honorable court. Your Excellencies, in this said appellant bundle, we've made prayers therein, and with the kind permission of this honorable court, we'll rely on every argument contained in the said appellant bundle, and we urge this court to grant the prayers contained therein. Now, with the kind permission of this honorable court, I would like to proceed with the arguments to make adumbration on the said argument. Firstly, Your Excellencies, I will be utilizing 20 minutes for the course of my argument. The senior appellant will be utilizing 20 minutes, and the junior appellant counsel will be utilizing 20 minutes, and we reserve 5 minutes for rebuttals. Your Excellencies, I would like to know if I am on record.
Sure, you proceed.
Oh, thank you. Thank you very much. Your Excellency, with your kind leave, I will now begin with the argument for grounds one. Your Excellency, grounds one has to do with the jurisdiction of the first instance court. And the first instance court was the Digital Economic Court, which received the claims of Ms. Raz Rani, which was the claimant before the first instance court and is presently responding before the Honorable Court. The first ground is as to whether the first instance court had the jurisdiction to entertain the claim of Ms. Raz Rani. And premised on this, counsel is submitting that the first instance court did not have the jurisdiction to entertain the claims of Ms. Raz Rani pursuant to Article 5A(1)(b) of the DIFC of the Judicial Authority Law. For purpose of emphasis, Article 5A(1)(b) of the Judicial Authority Law. Your Excellencies, counsel shall be premising its argument on two standpoints. One is that the parties did not operate from within the DIFC, And the second standpoint is that there's no proof that the server based in the DIFC was used for the conclusion of the said contract. Neither is there proof from the statement of fact that the node that is in the DIFC was used for the conclusion of the said contract. Your Excellency, I shall now begin with the first standpoint. The first standpoint is that the parties did not operate from within the DIFC. Your Excellencies, counsel shall be relying on judicial authorities and as well the DIFC laws. Firstly, is Article 5A(1)(b) of the Judicial Authority Law. Your Excellency, Article 5A(1)(b) of the Judicial Authority Law. And also, counsel shall be placing reliance on the case of Al-Khurafi versus Bank Saracen. Further, Your Excellencies, counsel shall place reliance on the case of Lucian and Latori. And also, we shall place reliance on the case of Gavin and Geno. Your Excellencies, Gavin and Geno. We provided the citation for these authorities in paragraph 4, in paragraph 5, in paragraph 6 of the appellant's bundle. Your Excellency, we direct the mind of this court to paragraph 4, paragraph 6, and paragraph 4, paragraph 5, and paragraph 6 of the appellant's respondent bundle, where we provided the citation and the court holding in these said cases. Your Excellency, it is the jurisprudence of this honorable court that this court will exercise jurisdiction when parties have operated or have transacted, or where the parties who have transacted within the DIFC jurisdiction. This therefore means that if the parties did not transact within the DIFC jurisdiction, then the DIFC court cannot have jurisdiction over the said parties that have come before this honorable court. Your Excellency, counsel shall now direct the mind of this honorable court to paragraph 3 of the case fact. Your Excellencies, paragraph 3 of the case fact. In paragraph 3 of the case fact, we are told that Ms. Rani lives in the Dubai, UAE. And the Dubai, UAE, Your Excellencies, is not within the DIFC jurisdiction. Further, Your Excellencies, we are told that Mr. Payne lives in the Sultanate of Oman. Your Excellencies, the Sultanate of Oman is not within the DIFC jurisdiction. It is therefore counsel's submission that it do not reside within the DIFC, and hence this court does not have jurisdiction pursuant to Article 5A(1)(b) of the Judicial Authority Law. This is our submission. Further, Your Excellency, we acknowledge, as is stated in paragraph 7 of the case fact, Your Excellency, paragraph 7 of the case fact, that Clevity has a node in the DIFC. However, Your Excellency, Clevity is not a party to this case. Clevity is not a party to this case. As can be seen, the parties to this case is late Payne and Ms. Razrani. Your Excellency, it is therefore our submission that the parties who are before this court did not transact within the DIFC jurisdiction, and hence this court does not have jurisdiction over the parties before the honorable court. Your Excellency, counsel shall now proceed to the second standpoint. The second standpoint is that there is no proof that the server or the node in the DIFC was used for the completion of the said contract. Your Excellency, counsel shall be placing reliance on the authority of Article 5A(1)(b) or Article 5A(1)(b) of the Judicial Authority Law. Further, Your Excellency, counsel shall be placing reliance on the case of Al-Khurafi and Bank Saracen. Al-Khurafi and Bank Saracen. Your Excellency, the jurisprudence of this court, Your Excellencies, is to the effect that it must be shown that the said commercial activity occurred within the DIFC jurisdiction. It must be shown that in whole or in part, the said transaction was concluded within the jurisdiction. However, Your Excellency, in this instant case, it is not the case, because Council acknowledges that Clevity has a node, as can be seen in paragraph 1 of the case fact. It has a node in the DIFC. However, there is no proof that this said node or the Clevity's platform in the DIFC was instrumental in concluding the said trade. There's no proof. Not the case shows that the node in the DIFC, the Clevity's node in the DIFC.
So, Mr. Peace, can you hear me? Your voice is not so clear. Can you repeat what you were saying for the last minute?
Thank you very much, Your Excellency. Your Excellency, am I audible now?
It's okay now. But you can be more.
Thank you very much, Your Excellency.
Be more cool and calm and just speak a little bit.
Yeah. Yes, Your Excellency. Yes.
Okay.
Yes, Your Excellency. Thank you very much. Yes, Your Excellencies. It is Council submission that we acknowledge, as it is stated in paragraph 1 of the case fact, that Clevity has a node within the DIFC, Your Excellency. It has a server within the DIFC. However, Your Excellency, there is no proof that this said node or the server within the DIFC was used for the completion of the said dispute trade. There is no proof. In the case fact, no allusion was made to the effect that the said node or the Clevity's platform in the DIFC was instrumental in reaching the said trade dispute. Your Excellency, and Article 5A1B is of the effect, Article 5A1B of the Judicial Authority Law of the DIFC is of the effect that a party that wants the court to exercise jurisdiction over its claim must show that the said contract was concluded, or the said commercial activity was concluded either in whole or in part within the DIFC jurisdiction. However, Your Excellency, in this case, there is no proof. After Your Excellency, it is Council submission that being that there is no proof that the node or the server in the DIFC was used for the conclusion of the said dispute trade, this court, the first instance court, which is the Digital Economy Court, did not have jurisdiction to entertain the claim of Ms. Razrani. Your Excellency, in conclusion of this said ground, the relevant questions that need to be asked is this. One, Your Excellency, the first question is this. One, is there proof that the parties operated within the DIFC jurisdiction? Your Excellency, the answer is no, as can be seen in paragraph 3 of the case fact, which states that the appellant and the respondent lives outside the DIFC jurisdiction. Further, Your Excellency, the second question that needs to be asked is this: is there proof that the Clevity's server or the Clevity's node in the DIFC was used for the conclusion of the said contract? Your Excellency, the answer is no, as there's no proof. Portion this, Your Excellencies, Senior Appellants Counsel humbly submits before this honorable court, and we pray that the first instance court did not have jurisdiction to entertain the claim of Mrs. Razrani. And we pray that this court resolve this issue in favor of the appellant. With your kind permission, this is the image of the Senior Appellant Counsel on grounds 1 before this honorable court.
Mr. Peace, thank you for your submission, but let me ask you something. Now, have you had a look regarding Dubai laws, which sometimes referring to the IFC as a chosen law for the parties who are residents in the United Arab Emirates? They can go and choose the IFC courts to be representing them as a chosen court. Have you heard about this law? Have you read this law?
Yes, Your Excellency. I'm abreast with the said law that parties can decide to choose the DIFC courts for adjudication when a dispute arises.
So, okay, and in light of this article, the parties can have the right to choose the competent law, a court, to be to conducting such dispute. So what's your response regarding this article?
Your Excellencies, the article, yes, the article is of effect that parties can choose the DISC courts when disputes arise. However, Your Excellency, there's nothing in the case facts. We are bound by the case facts. There's nothing in the case facts, neither the agreement between the said parties that the DIFC court is to have natural jurisdiction over a dispute that may arise between the said parties. There's nothing to this effect. If there was something to this effect, then this court would have had jurisdiction. Your Excellency, I direct the mind of this court to the case of Al-Khurafi and Baksarasin. In Al-Khurafi and Baksarasin, the court stressed, affirming that said Dubai laws that parties can choose this court in their agreements whenever dispute arises. However, in this instant case, the parties before this honorable court, there's nothing that shows in the case fact that they chose the DIFC court as the court that has natural jurisdiction over a dispute. Your Excellency, this is our humble submission.
Thank you, Mr. Fisher. Yes, Mr. Fisher, it's yours.
Yeah, thanks, Mr. Juma. I will request, and I'll put a light on a para 64 as you make a reference of Al-Khurafi case of DIFC. If you see para 64 of the same case, which makes the reference, which reads out that requirement that the transaction of incident shall be related to DIFC activities in inverted commas, simply means that such incident or transaction should have been in furtherance of or as a result of a particular commercial activity carried on in the DIFC. So what it means is says that related to DIFC activities. So isn't it a presence of node in DIFC gives the jurisdiction to the DIFC, which makes a clear reference that yes, that the clear requirement is that transaction shall be related to DIFC activities.
Thank you, Your Excellency, for that question. In fact, that question buttresses the points of the appellant very well. Your Excellency, the said Al-Khurafi's case, it's paragraph 64. In paragraph 64 of the said case, it said that it was related to a DIFC activity. So, Your Excellency, DIFC activities, and we acknowledge, as it is stated in paragraph 7 of the case fact, that in paragraph 1 of the case fact, that the Clevities platform has a node and a server in the DIFC. However, Your Excellency, it is our submission that there is no proof that the said node or the server in the DIFC was instrumental in enriching said activity. It must be instrumental in enriching this said commercial activity. How do we know that the said node was instrumental in enriching this said commercial activity? There is no proof. It might have been that this said node was not even instrumental at all. But being that there's nothing as regards this that's contained in the said fact, this court cannot make assumptions. This court is not the court of assumptions. This court relies and deals with proof only. On proof only, that's what this court relies on. Your Excellency, it is premised on this that we are submitting that being that there is no proof, the first instance court did not have jurisdiction to entertain the suit of the respondents, that's the respondent claimant.
Okay. So isn't it like in Al-Khurafi case itself, if I can refer it to the application of FNC doctrine, where, like DIFC can claim the jurisdiction where the interest of justice, convenience, and fairness lies. So in that FNC jurisdiction, how appellant would claim that the jurisdiction should be somewhere else? And which court should have,
Your Excellency,
which court should have the jurisdiction as per the FNC principle, if I am talking about it?
Thank you, Your Excellency. Your Excellency, firstly, justice is a two-way traffic. There's justice for the appellant and there's justice for the respondent. And also there's objective justice, which this court is mandated to do, Your Excellency. The said transaction between the appellant and the respondent, the said agreement did not have contemplation of utilizing the DIFC court. And being that the appellant is objecting to the use of the DIFC court, we acknowledge the fact that this court may want to exercise jurisdiction. However, as was stated in Lushan and Laturi, and as Gavin and Gino, where there is no express agreement as to this effect, that this court is to exercise jurisdiction, this court cannot exercise jurisdiction. Another competent court can exercise jurisdiction. Another competent court that can be agreed that an agreement can reach between the appellant and the respondent can exercise jurisdiction. It can be another court in the Dubai. It can be another court in Dubai. However, not a court within the DIFC jurisdiction. Your Excellency, this is the submission of the Senior Appellant Counsel.
Okay, thank you very much for your statement. Mr. Vishal, do you want to call the other parties?
Yes, Mr. Verma. I'll request, with your permission, the other parties to present their facts on the defendant side. I request defendant to present the case.
Anyone representing the other party here can hear us?
May I ask the host to just check with them? Possible?
Sure. Payal, Shakira. Can you hear us?
Yes, am I audible?
Yes, please go ahead.
Yeah, sorry, my mic wasn't working. 1 second.
That's all right.
May it please the court, my name is Paljeen and I appear as a senior respondent on behalf of the respondent, Razrani, in these hearings with my learned junior, Ms. Shakira Zainab. If it pleases Your Honor, may I proceed to say the facts?
Please proceed.
The appellant and respondent are both users of the Clevity platform, a digital platform to trade in cryptocurrency. Owing to a system glitch brought on by the routine upgrade, the appellant and respondent were only users who could trade the cryptocurrency Yapple. A disputed deal was completed between the parties at a price 250 times higher than the current market rate, for which the respondent brought proceedings against the appellant on the grounds that the trade is void for unilateral mistake. The Court of First Instance.
Shakira, can you hear me?
Yes.
Yes. Mr. Fishel, are you there?
Yes, Mr. Ahmad, I'm here.
Okay, Mr. Fishel, I think now we will start again because I was not enabled just to hear anything. So I think the other team represented by Shakira, Zainab. Shakira.
My name is. I'm using Shakira's laptop because I'm not able to use mine.
So what's your name?
Payal Jain.
Payal, you will be representing the respondent as a senior?
Yes.
Okay, I'm sorry, just to let you start again. Can you do it again, please?
No problem. May it please the court. My name is Payal Jain and I appear as a senior respondent on behalf of the respondent, Razrani, in these hearings with my learned junior, Ms. Shakira Zainab. If it pleases Your Honor, may I proceed to state the facts?
Go ahead, please.
The appellant and respondent are both users of the Clevity platform, a digital platform to trade in cryptocurrency. Owing to a system glitch brought on by the routine upgrade, the appellant and respondent were the only users who could trade the cryptocurrency Yapple. A disputed trade was completed between the parties at a price 250 times higher than the current market rate, at which the respondent brought proceedings against the appellant on the grounds that the trade is void for unilateral mistake. The Court of First Instance ruled in favor of the respondent, where the decision was then appealed by the appellant. In response to the submissions made to Your Honor by the appellant, I shall be addressing the first point of appeal through an essential submission opposing the appellant's views. I would like to direct your honor to page 5, paragraph 8 of the code bundle, namely, the DRC has jurisdiction under Article 5A1B of the Judicial Authority Law. Thus, the appellant's continued performance is not justified. In this case, Your Honor, I would like to make a submission in response to the first ground of appeal as previously stated, and this will place a greater emphasis on the factors asserting that as accurately determined by the Court of First Instance and Ms. Rani, the DRC court has jurisdiction over the claim and was obligated to consider the claim and authorize an evaluation that the trade is void for unilateral mistake. If it may please the court, I would like to proceed with my submission. Your Honor, I would like to proceed by stating the Court of First Instance has exclusive jurisdiction as in Article 5A1B of the Judicial Authority Law, which indicates that claims arising in relation to a contract, whether partly or wholly concluded, finalized, or performed within the DRC comes under the jurisdiction of DRC. Additionally, the lex situs of the crypto asset is also considered when determining the jurisdiction of the claim. Thus, the appropriate jurisdiction for a valid claim is the place where the individual or the company who owns the asset is domiciled or where the damages have occurred, as Your Honor noted in the case of Iron Sciences and Persons Unknown and others reported on 21 December 2020 Commercial Code, which can be found at page 21 of the Respondent's Code bundle. To support this argument, I would like to present the case of Iron Sciences and Persons Unknown and others reported on 21 December 2020 Commercial Code. Would Your Honor prefer a brief summary of the following case?
Yes, please.
Iron Sciences and its sole director, Duncan Johns, were victims of an alleged initial coin offering fraud. They claimed to have transferred Bitcoin after being convinced by unidentified parties that they were buying authentic cryptocurrency goods, only to learn that the recipient was a fraud. To protect the transferred Bitcoin, Iron Sciences and Mr. Johns applied a proprietary injunction, a global freezing order against the unidentified parties, and a disclosure order which was directed at cryptocurrencies exchanges in the form of a bank trust order. The case's primary question was whether the court had jurisdiction in the application for interim relief and if the governing law of the claim was English law. The court referred to the analysis of Professor Andrew Dixon at page 23, paragraph 13, in determining that the lex situs of the cryptocurrency is the law applicable where a person or company who rightfully owns the cryptocurrency is domiciled or has its registered office. In other words, in this case, it is the English law. The court concluded that the applicants had shown there was a serious issue to be tried on the merits of the claims being brought or intimated in deceit, unlawful means conspiracy, and by the way of an equitable proprietary claim as highlighted on page 22, paragraph 13 in the Respondent's Code bundle. Furthermore, the proper jurisdiction for the trial of the claim was found to be England. The claim may have arisen from the events that occurred within the jurisdiction. The damage occurred within the jurisdiction. The applicants were domiciled in England, and the relevant funds and Bitcoin were based in England, which allowed the applicants to satisfy the requirements for serving outside the jurisdiction as highlighted on page 24, paragraph 16 in the Respondent's Code bundle. This is in accordance with the legal interpretation of the Article 5 of the Judicial Authority Law, which states that the basic requirement to have a jurisdiction is to have a contract be concluded or the acts taken under the contract to be performed wholly or in part within the DRC. The criteria is satisfied because Clevity functioned using a distributed ledger, and it can be inferred from the contract between the users that a part of the business was run from DRC as one of the servers is located there. The lex situs of YAPL would thus be in DRC as it is the place where Clevity is domiciled partly. Your Honor, I would further like to emphasize the first ground of appeal made by the appellants regarding DRC having a jurisdiction over the claim, and the Court of Appeal should validate the decision reached by the Court of First Instance. According to the lex situs of the crypto assets, YAPL would be in DRC as one of the nodes of the platform is based in DRC, such that the damage may have occurred in the jurisdiction as well, and hence the decision of the Court of First Instance should be upheld. Your Honor, to highlight my viewpoint, I would like to present the case of Fetch AR Limited and another and persons unknown and others reported in 2021 Commercial Code of England and Wales High Court at page 2254 that can be found at page 25 of the Respondents' Code bundle. Would Your Honor prefer a brief summary of the following case?
Payal, thank you for what you have said. But let me ask you now, you are saying that the damages happened within the IFC jurisdiction. However, as you know, this is, a e-commerce, which that means hundreds of nodes are available for this transaction under Clifty. So how do you link the damage happened in Dubai? It could be happened through another node from another part of the world.
And I would like to say it was written in the judgment, Your Honor, it was written in the judgment of, which judgment was it? Of judgment of Fetch IL Limited, that the case that I was going to say next, that it says in the judgment that the law of the place of residence or business of the participant with which the participation that the object of transaction is mostly connected. The object of transaction, that is YAPL over here, is closely connected to DIFC as one of the servers is based in DIFC, with which I'm establishing that there is jurisdiction present.
So again, I'm asking you, there's difference between the damage and the location of the transaction where it's occurred, the transaction process. Imagine that this damage happened and one of other nodes which are linked with this node, and this happened outside of the IFC jurisdiction. So what you can say in this part, how you will defend this argument? There is nodes, and these nodes are, and as per my knowledge, that these nodes connected to each other and supporting each other. So might one of the nodes affecting the node was located in the IFC, and the cause from that node which outside of the IFC jurisdiction.
Yes, Your Honor. May I come back to you in a few minutes, please, for this answer, for this question?
Well, it's okay. You can continue.
Okay, thank you, Your Honor. Would Your Honor prefer a brief summary of the Fetch Limited and another and persons unknown and others, which was reported in 2021 Commercial Code of England and Wales High Court?
Yes, go ahead, please.
An English firm, Fetch AI Limited, and a Singaporean company, Fetch AI Foundation Pte. Limited, filed this lawsuit, alleging that the fraudsters had access to the first claimant's finance accounts, which included a variety of the cryptocurrencies. The perpetrators then traded these cryptocurrencies for amounts that were far below the market value in order to move them implicitly to their own wallets. This value drop was estimated to be about $2.6 million. Claims for confidentiality breaches, unjust enrichment, and an equitable proprietary claim based on the unlawfully acquired property being held on a constructive trust were brought by the claimant. The critical question in this case was whether England and Wales had a jurisdiction to hear the claim where the cryptocurrencies did not belong to a specific place and the claim was against unknown defendants. The court applying the Iron Science case was persuaded that there was a serious issue to be tried regarding whether the cryptocurrency is property or a chosen action for the purposes of English law. The lex situs, which is the law of the place where the asset is situated of a cryptocurrency, is the location where the person or company who owns it is domiciled. The primary applicant and the owner of the accounts was a resident of England, and the law of the place where the object of transaction is closely connected to applies. Therefore, the English courts had jurisdiction as highlighted at page 27, paragraph 13 of the court bundle. Your Honor, in the case mentioned above, it is evident that the relevant asset YAPL may be based in DIFC, and the object of the transaction YAPL is closely connected to DIFC, with which the respondent satisfies the standards of serving outside the jurisdiction. With this, Your Honor, my submission is concluded. If Your Honor has no further questions, shall I proceed with my conclusion?
Yes, please. Continue.
In conclusion, Your Honor, the respondent contends that the judge of the first of the Court of First Instance did not make an error in concluding that the DRC Court had jurisdiction over the claim by the respondent against the appellant under Article 5A1B of the Judicial Authority Law as Clevity operated a distributed ledger with a node in the DRC. Under the provisions of the DRC law and the supporting case law, a cryptocurrency can be viewed as a property, and thus the lex status of a crypto asset is similar to that of a physical asset. The lex status of the YAPL would thus be in DRC, as it is the place where Clevity is domiciled partly. The case also has a serious issue to be tried on the merits of their claims being brought in, as it is addressing a claim of the trade being disputed for unilateral mistake. My learned junior, Ms. Shakira, will later address Your Honor to the second appeal in response to the appellant's claim of the disputed trade not being void for unilateral mistake under Article 37(1)(a) of the DRC contract law. Unless I can be of any additional assistance, I bring my submissions to a close.
Thank you, Payal, for your submission. So I think your colleague. Who's your colleague going to be? Sorry again, give me his name.
So the junior respondent, that is me, Shakra Zainab, will go.
You are the junior respondent, right?
Yes.
Okay, Mr. Fisher.
Your Excellency.
Yes, please.
Yes, please, Your Excellency. According to the rules of the rules for the competition, when the senior respondent counsel is done with the argument, I am to make rebuttals.
I'm sorry, it is your time. I'm sorry. Sorry. Mr. Fisher, just 1 minute. Mr. Fisher?
Yeah.
Are you there?
Yes.
Okay.
Yes, Mr.
Yes. Now the senior appellant, he should show up. I'm sorry. Yeah, it's yours now.
Yes. Thank you. Thank you very much, Your Excellency. Thank you, Your Excellency.
Yes.
Your Excellency, we have 2 points of rebuttals. Firstly, the senior respondent counsel submitted that the lex status of Clevity is the DIFC, and hence it ought to be considered. Your Excellency, it is our submission that we acknowledge the fact that the DIFC has a node, just one node in the DIFC, within the DIFC. However, it does not mean that the lex status of Clevity is the DIFC. Does not mean that the lex status is the DIFC. Your Excellency, pursuant to Article 5A1B of the Judicial Authority Law, the said party who is residing within the DIFC jurisdiction has to be a party before this court can have jurisdiction. And as can be seen, Clevity is not a party to this suit, Your Excellency. Clevity is not a party to this suit. The parties to this suit is Mr. Payne and Ms. Razrani. These are the only parties that are before this honorable court. On the second point of rebuttal, Your Excellency, the senior respondent counsel submitted that Clevity operates a distributed ledger. We acknowledge this. And the counsel for that submitted that because it operates a distributed ledger and it has a node in the DIFC, then the DIFC ought to have natural jurisdiction. Your Excellency, this is not the position of the law. Your Excellency, this is not the position of the law. The position of the law, Your Excellency, as was stated in the case of Gavin and Gino, is that there must be a proof that one, the parties operated within the DIFC jurisdiction, or that the said transaction occurred within the DIFC jurisdiction. We acknowledge the fact that Clevity has a node in the DIFC jurisdiction. However, there is no proof, there is no scintilla of evidence that this said node was used for the completion of the said contract, Your Excellency. It could have been that it was a node that is in another location that was used for the completion of the said contract. It could have even been that a node in China or a Clevity server in China was used for the completion of the said contract, Your Excellency. There is no proof that the said node in the DIFC was used for the completion of the said contract. Further, Your Excellency, we place reliance on the case of Lucian and Latour, and I direct demand of this court to paragraph 6 of the appellant bundle. Paragraph 6 of the appellant bundle, Your Excellency. The court ruled, the small claims court ruled that the DIFC courts do not have default jurisdiction over the claim of parties who are based outside the DIFC. Your Excellency, this completes the rebuttal of points of law from the senior appellant counsel. Thank you very much.
Thank you very much, Mr. Peace. Now, Mr. Faisal, do you have anything to be added in this part?
Yeah, I would just request the appellant, senior appellant, to put a light on the Article 5A1B. So it clearly states that, look, civil or commercial claims and actions arising out of or relating to a contract or promised contract, whether party or wholly concluded, finalized, or performed within DIFC, or will be performed, or is supposed to be performed within DIFC pursuant to express or implied terms stipulated in the contract. Now, if we can break it down, so isn't it like there is a relation, there is a node in DIFC will give a jurisdiction because the actions are arising out of some contract which both of the parties agreed to. If I can say that the party who used the Clarity platform, they signed a standard contract. Now, each and every node of Clarity, which is based in several jurisdictions, one of the node is in DIFC. So they are related or interrelated to a AI system accordingly which they are working. So isn't it like the actions, whether it is arising from any node in the world, but that particular node present in DIFC gives an access to the jurisdiction that DIFC has?
Thank you very much, Your Excellency, for that question. Your Excellency, firstly, in answering the question of this honorable court, we acknowledge that there is a node in the DIFC, and Article 5A1B is of the effect that either in whole or in part, the said commercial activity must have occurred within the DIFC. But Your Excellency, the point that Appellant Counsel is putting forward is that we do not know, there is no proof that the said node in the DIFC, the Clevities node in the DIFC, was used for the completion of the said contract. This court will not have jurisdiction just because there is a node in the DIFC. It must be shown that the said node was instrumental in the conclusion of the said dispute contract. And the onus to show that is on the respondent claimant, because they are the ones who brought the suit before the first instance court, which is the Digital Economic Court. The onus is on them to prove that the said node in the DIFC was used for the conclusion of the said dispute contract. And on the second point in reply, Your Excellency, is that there is nowhere in the statement of facts. I have the statement of fact with me, Your Excellency, which is the Moot problem, the DIFC Digital Economy Moot problem. There's nowhere in the Moot problem where it stated that the parties have agreed expressly to resort to the DIFC courts. There's nowhere it stated, Your Excellency. This court cannot make assumptions. This court is not a Father Christmas. It cannot be granting or giving out claims that parties do not ask for. Your Excellency, it is our humble submission that there is no agreement between the parties as to the use of the DIFC courts, particularly when the parties are not even residing within the DIFC. If at all, Clevity would have been, if Clevity was a party to this suit, this court would have had jurisdiction. However, Clevity is not even a party. Your Excellency, Clevity is not a party. There are only two parties before this court. Number one is Mr. Payne, who is a party. And secondly is Ms. Razrani. These are the only parties before this honorable court. Clevity is not a party. Thank you, Your Excellency. This is the submission of the Senior Appellant Counsel. We are most grateful, Your Excellency. We are grateful.
Even if Clevity is not a party, but two parties who signed their Clevity platform and they were using it, there was a standard agreement they signed. And as per the clause B, it says that relating to a contract. So isn't it both the parties is related to one contract, even though Clevity is not a party to that claim or to the case?
Your Excellency, I would like to be guided to where it is stated in the Moot problem that the parties made an agreement to submit to the DIFC court, because from the Moot problem, there's no way it is stated that the parties have agreed expressly to, when a dispute arises, that the DIFC court is going to have natural jurisdiction. Your Excellency, there's no way it is stated. We would like to be guided. We are obliged, Your Excellency.
So thank you, Mr. Peace, for us to just maintain the time. I think now I think we have the time now for the junior appellant.
Yes, Your Excellency, I will not, Your Excellency, with the kind permission of this court, I will not defer proceedings. I will yield the floor to the Junior Appellant Counsel. Thank you very much. We are grateful.
You're welcome. Mr. Kefas? Mr. Kefas, are you around?
Yes, Mr. Kefas is around, but he is the senior respondent counsel in this case, while my humble self, P. Ibinovia, is the junior appellant counsel in this case, and I'm ready to make my argument before this honorable court.
Please start.
Thank you, Your Excellency. May it please this honorable court. Entering appearance is P. Ibinovia on behalf of the appellant in this case, between Mr. Late Payne and Ms. Raz Rani. Your Excellency, I am the junior appellant counsel in this case, and I shall be arguing on grounds two in this appeal that has been distilled for determination, which poses the question whether the first instance court was in error when it concluded that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37, sub 1, paragraph A of the DIFC contract law that Ms. Razi, the respondent, showed that a reasonable trader with knowledge of the circumstances surrounding the transaction would have concluded that the dispute trade was the result of an error. On these grounds, Your Excellencies, it is counsel responsible submission that the first instance court's conclusion that Article 37, sub 1, paragraph A of the DIFC contract law was satisfied simply because it could be shown and established that a reasonable trader with knowledge of the circumstances surrounding transaction would have concluded that the trade was a result of an error was grossly negligent, was grossly erroneous, Your Excellency, and does not reflect the true position of the law on this subject matter. Your Excellencies, counsel's argument shall be predicated upon three pillars. The first pillar is that based on the circumstances of this case, Article 37, sub 1, paragraph A of the DIFC contract law, which is the law governing this subject matter, cannot be applied simply because the conditions necessary for its application were not satisfied in this case. The second pillar upon which counsel's argument is predicated upon is that the error or mistake allegedly made in this case was made by the respondent unilaterally and negligently, and that pursuant to Article 37, sub 2, paragraph A and B of the DIFC contract law does not serve as a valid ground for the avoidance of the dispute trade between the appellant and the respondents. Your Excellency, my third and final pillar is that the first instance court's reliance on the dissenting judgment given by a foreign court in the case of Quinon and B2C2 was wrong, as it does not reflect the true position of the law in this case. Your Excellency, before delving into the substance of my argument, it is imperative for me to state the following. That one, the applicable law governing the subject matter in this case is the DIFC contract law of 2004, and that in order to do a just and valid determination of this ground of appeal, reference should be made only at all times to the provisions of the DIFC contract law of 2004. At this juncture, Your Excellency, with your kind permission, counsel would like to proceed into the substantive part of his argument.
Yes, please. You can go ahead.
Thank you, Your Excellency. On the first pillar upon which counsel's argument is predicated upon, it is submitted that the provision of Article 37, subparagraph A, cannot be applied in this case, simply because the conditions necessary for its application were not satisfied in this instance case. Your Excellency, based on the provisions of Article 37, sub 1, paragraph A of the DIFC contract law of 2004, These conditions include that one, there is a mistaken party on the one hand, and that on the other hand, the other party either made the same mistake, was also mistaken, or caused the mistake, or knew or ought to have known of the mistake, so that it was contrary to reasonable standards of fair dealing to leave the other party in error. Your Excellencies, a painstaking and holistic perusal of a statement of facts clearly shows that at no point in time was the appellant mistaken, neither was he the cause of the mistake, nor did he know or ought to have known of the mistake, Your Excellency. Of course, it is true that the respondent was mistaken. However, this mistake was not made by the appellant, neither was he aware of the mistake. How then, Your Excellency, in Article 37, sub-1, paragraph A of the DIFC contract law, which governs this ground of appeal, be made to be applicable in this case when it is clear that the conditions necessary for its application were not satisfied? Your Excellency, it is crystal clear that the conditions necessary for the application of Article 37, sub-1, paragraph A of the DIFC contract law was not satisfied. And as such, it is counsel's submission that Article 37 cannot be applied on the grounds that the necessary conditions were not satisfied. Moving on to my second pillar, counsel would like to read to the hearing of this honorable court the provisions of Article 37, sub 2 of the DIFC contract law.
Okay, but please try to make it within less than 3 minutes.
Thank you, Your Excellency. I would like to summarize the provisions of Article 37, sub 2 for the sake of time, Your Excellency. Your Excellency, the object and purpose of the provision of Article 37, sub 2 is that where it is found that a party not only made a unilateral mistake, but was also negligent in doing so, and that the risk of his mistake was assumed by that party in question, the law is that the mistaken party will be unable to avoid the contract. Your Excellency, from the statement of facts, particularly paragraph 7 and 8, it is clearly seen that the respondent, Ms. Razi, admitted that she made a mistake while programming Alpha to buy Yapol at the best price. Also, she stated that if she had known, Alpha would not have been programmed to buy Yapol at the best available price. And lastly, Your Excellency, she instituted his case at the DIFC, praying the honorable court to avoid this contract on the grounds of a unilateral mistake. All of these clearly leads to the irresistible conclusion that the mistake that was made in this case was a unilateral mistake, and it was a negligent mistake on our part, Your Excellency. And as such, it is impossible for this to serve as a valid ground for the disputed trade between the respondent and the appellant to be avoided in this case. On these grounds, Your Excellency, it is counsel's opposed submission that Article 37 cannot, will not, and shall not be a ground for the avoidance of the trade and contract between the parties, Your Excellency. On counsel's last pillar, it is my submission that the first instance court was wrong to have relied on the dissenting opinion of the case of Quinon and B2C2 on the following grounds. Firstly, a dissenting opinion is regarded in law as an obiter that has no legal importance or binding effects in subsequent cases. Also, Your Lordship, it was wrong and grossly irresponsible, with due respect to the DIFC court, for them to have made reference to that case where there is already a provision under the DIFC contract law of 2004 that provides for what the law should be on the subject matter at hand. In the light of this, Your Excellency, it is strongly submitted that reliance on a dissenting opinion in the case of Quinon and B2C2 by the first instance court was grossly erroneous, as not only is it a dissenting opinion that has no legal importance or binding effects, it is also contrary to the provisions of Article 37, sub 1, paragraph A of the DIFC contract law, which is applicable law on this subject matter. Owing to the arguments adumbrated by counsel.
Mr. Shimas, thank you very much for your submission because of maintaining
Thank
the
you,
time.
Excellency.
Thank you, thank you. And now
Thank you,
this is the
Excellency.
time. Thank you, you're welcome. It's the time for the junior respondent.
Yes, Your Honor. Can I start?
Yes, can you use your name, please?
Shakra Zainab.
Shakra. Okay, Shakra, you will have 15 minutes, please.
Okay. Yes. Thank you. Your Honor, my name is Shakra Zainab, Junior Counsel for the respondent in this matter. I shall be dealing with ground 2 of this appeal, which states that the first instance did not err in concluding that the dispute trade between the respondent and the appellant was a result of an error. I shall, in support of this, make two submissions. First, a reasonable person should have known or ought to have known about the mistake. And second, one party is not allowed to take advantage of a mistake made by the other. If it pleases Your Honor, I will begin with my first submission. Article 37, Section 1, Part A of DIFC Contract Law on page number 8 states that the other party made by the same mistake or was also mistaken or caused this mistake or knew or ought to have known of the mistake, and it was contrary to the reasonable commercial standard of fair dealings to leave the mistaken party in error. This article is based upon Article 3.5.1 of the UNIDROIT Principle of the International Commercial Contract of the year 2004 on page number 98 to 99, which briefly explains the article. On page 100 of the UNIDROIT Principles, it mentions that the article indicates that a mistaken party may avoid a contract only if the other party satisfies one of the four conditions laid down under Article 37, Section 1. The conditions are as follows. First, both parties labored under the same mistake. Second, the error of the mistaken party is caused by the other party. Third, the other party knew or ought to have known of the error of the mistaken party and that it was contrary to the reasonable commercial standards of fair dealings to leave the mistaken party in error. And lastly, the party other than the mistaken party had not reasonably acted in reliance on the contract up to the time of avoidance. Your Honor, the third out of the four conditions may satisfy the ground as the reasonable test must be taken to determine if the appellant had ought to know the mistake. I'll be referring Your Honor to the case Chui King Kong and the other and DigilandMail.com Private Limited reported in the second volume of the Law Report of the Commonwealth in 2005 on page 28. Your Honor, for further guidance, I would like to direct you to page number 7, paragraph 18, 19, and 20 of the skeleton argument in the respondent's court bundle. For further judgment on this case, I would like to guide Your Honor by clicking on the case name in the index on page number 1. Page number 1. For the benefit of Your Honor, the facts of the case are as follows. In this case, the respondent DigilandMail.com Private Limited was an online IT company that sold related softwares and hardware from Singapore. They were selling HP laser printers, and an employee accidentally made a mistake as to the price of the printer on their website. It was listed at the price of $66 when it was advertised on the official website for $3,854. This was not noticed by the company until over 4,000 printers were ordered. The appellant had ordered over 100 printers each at this price. When the respondent discovered this mistake on their website, they sent an email to the appellant to say they would not be fulfilling this order. The courts have stated regarding the reasonable test in paragraph 37 that if party ought to have realized the mistake in the light of the surrounding circumstances, that will be classified as actual knowledge within the extended definition of willfully shutting one's eyes to the obvious. In the light of the circumstances, the appellant did agree that there might be a mistake when, in our case, when Mr. Payne said, even if Ms. Razi had made a mistake. When mentioning Ms. Razi's mistake, the appellant willfully shut his eyes from the possibility of a mistake present in the disputed trade. Following this, the Court of Digiland Mail has also mentioned in paragraph 35 that phrases such as must have known and could not reasonably have supposed are evidential factors to find whether the non-mistaken party did in fact know of the error made by the mistaken party. Furthermore, Your Honor, I would like to draw your attention towards paragraph 38 of Digiland case on page number 17 of the respondent's court bundle. The court of the Digiland case cites the High Court of the same case name reported in the second volume of the Singaporean Law Report on page number 594, paragraph 145, stating that the reasonable man would harbor a real suspicion that the price may not be correct or that there may be some troubling underlying basis for such a pricing. In our case, when the disputed trade was concluded at the price 250 times greater than the prevailing market price, the appellant ought to know that the trade was a mistake. In conclusion, under the reasonable man test, the appellant ought to know the mistake when the error occurred. If Your Honor has no further questions, I will move on to my second submission.
It's okay. Mr. Fisher, I'm just saying to Mr. Fisher, the co-judge, if you has any things you want to add, Mr. Fisher.
Yeah, I would ask the defendant that when Ms. Razi took the algorithm and look, this AI technology, this is unprecedented, and it can be quite known, like if you are not filtering something, unless you are not affixing the price for say minimum was 50,000, and you might not know, like it's the exception. For 30 minutes, the site went down, but isn't it like it can be predicted that market might change given this is a form of crypto, which is a digital asset. So it might change or may not change. So there is unprecedented, which is very contingent in nature. So one might, trigger or make the algorithm or whatever they are using, any online way of dealing with the currency. It should be reasonable, because you may not know, like you have 250,000 in your pocket, but next day you can sell one coin for 250,000 for any reason whatsoever. So it cannot be predicted, I believe, but the party has to be very sure that they are into a market which is very unprecedented. So isn't it like she must be having a knowledge that, yeah, it is better to figure out an algorithm or use an algorithm in such a way that also protects my interest.
Yes, Your Honor. Well, it can said otherwise as well in terms of Mr. Payne. He could have also acknowledged the fact that there might be a fluctuation as well.
I will just interrupt you and will say that there was a knowledge, and it was a knowledge that he will accept the best acceptable apples in the market with the best acceptable price. He got it, and he is pretty happy with the transaction. At the same side, if you go with I cannot agree on this point that you just figure out something either way, or you make certain filters that protects you in the future, or you are just going very contingently. It cannot be accepted. Tomorrow you might incur 1 million or 2 million purchasing one or two apples, maybe for any reasons. So this market is very contingent. Isn't it like someone who is investing must know that there are the chances, there are the gray areas that might happen for the investment that they are undertaking?
Yes.
Thank you, Mr. Fishel. But Mr. Shakira, because the time is running fast, you have another submission you want to add?
Yes, Your Honor.
You have 3 minutes, please. Huh?
Okay. So my second submission is that one party is not allowed to take advantage of a mistake made by the other. I'll be referring Your Honor to the case of Hartog and Collin and Shields, reported in the third volume of All England Law Reports on page number 566. For the benefit of Your Honor, the facts of the case are as follows. The defendants contract to sell 13,000 Argentine hareskins to the plaintiff, but an alleged mistake, they offered the goods at certain prices per pound instead of at those prices per piece. which was approximately 1/3 that of a pound. In verbal and written negotiation, which took place before the sale, references had always been made to the price per piece and never to the price per pound. And experts' evidence was given that Argentine hareskins were generally sold at a price per piece. Judge Singleton from the aforementioned case stated that the defendants knew about the mistake and took advantage of the claimant. In other words, realizing that there was a mistake, the plaintiff did what is described as snapping up the offer. This can be applied to our case as the appellant ought to know there is a mistake because of the absurd fluctuation of the price and took that advantage as he is getting $250,000 out of the respondent's bank account. If your honor has no further questions, I'll be moving on to my conclusion.
Yes, please. You have 1 minute.
Yeah. On this ground and the previous ground given by my learned senior, it is accordingly submitted that your honor should dismiss the appeal and conclude that the court of first instance did not make an error in concluding that the DIFC court had jurisdiction over the claim by the respondents against the appellant under the Article 5 Part A 1 Part B of the Judicial Authority Law, and the reasonable trader would have known that the dispute trade was a result from an error which is in line with the previous decision reached. Unless I can further assist the court, my submissions are complete.
Thank you, Shakira. And that is the time now for the junior appellant.
Thank you, Your Excellency. The Junior Appellant Counsel would like to make some rebuttals on the arguments brought before this court by the Junior Respondent Counsel of the respondent.
Yes, please go ahead.
Thank you, Your Excellency. Firstly, during the course of the Junior Respondent arguments, she stated that the appellant shut his eyes when he said that even if Ms. Razi had made a mistake, even with the statement that he shut his eyes by making that mistake, Your Excellency, that is a wrong misinterpretation of the statement of the appellant. For context and better understanding, I would like to read paragraph 8 of the statement of facts. Paragraph 8 states that Mr. Payne said that even if Ms. Razi had made a mistake, when he programmed better, he did not make the same mistake as Ms. Razi or cause a mistake, and he did not know and could not have known about Ms. Razi's mistake, and so there could be no grounds to avoid this mistake. Simply put, the appellant meant that at the point where he programmed beta, there was no mistake of the respondent that he ought to have been aware of. Clearly, this shows that the mistake that flowed from this transaction was a unilateral mistake. And the principle that guides the operation of another mistake under the common law is that another mistake is not a ground for avoiding or voiding a contract, except when the other party either caused the mistake or ought to have known of the mistake. And from the statement of facts before this honorable court, nowhere is it stated, nowhere is it contained that the appellant knew of the mistake, caused the mistake, or could have known of the mistake. Your Excellency, this is an unprecedented and novel matter, simply because it was a program under which contract was concluded. And the time the mistake could have been made is only at the time when the program was made by both parties. And if there was no mistake at that time, then clearly the respondent cannot claim that the mistake had been making, which my client ought to have known about. Also, Your Excellency, the second rebuttal that I have is as regards the interpretation of the provision of Article 37, sub-1, paragraph A of the DIFC contract law by the respondent, where she stated that the appellant, where she failed to take into consideration that the time of making the mistake was at the point of conclusion of the contract, Your Excellency. That provision clearly says that a contract can only be avoided where at the point of concluding a contract, a mistake was made by a party and the other party ought to have known of the mistake or caused the mistake. Your Excellency, it's my submission that the moment the contract was concluded was when the program of the appellant made an offer to the program of the respondent, and a contract was concluded. Your Excellency, at that point in time, no mistake was made by both parties. And as such, the provision of Article 37, sub 1, paragraph A cannot be applied simply because the conditions necessary for its application were not satisfied in this case. Thank you, Your Excellency.
Thank you for your submission. The co-judge, Mr. Official, you want to interfere in this part?
No, we can proceed ahead. Yeah.
Thank you, co-judge Official, and thank you for all the parties. And I think now we have ended this session. Thank you for all submission and all the parties. Thank you very much. Judge, we will see you in the room, inshallah.
Thank you.
Yeah. I will ask Judge to stay on the call or for some time, and
no, we will go to the judge room.
Yeah,
it's better.
On judge.
Yeah, it's more, yeah. But let us leave this room and join the judge room, okay?
Yeah, I would just say that to the parties from the appellants and defendant side, it was really good of you, whatever research you have done so, and we really appreciate your interpretation skills, and would be happy to see you in the court if possible in the future. Yeah.
Thank you, Your Excellency.
Nice day.
We are grateful.
Thank you for all of you. Thank you.